you'll have to appear in person, ma'am.
Okay.
That way we can assure you're not smoking and not having sex while you're in court.
Wow.
Yeah. Wow. You should see the video. Mute her and get her out of my court. Yeah, we can hear you.
Okay. Jessica Bruscella.
Your Honor, we'd be requesting an adjournment this time. There's some more.
She's going to need to, let me just stop you. She's going to need to appear in person. We've had a problem with this defendant. We've kicked her out of our courtroom, I think on 2 occasions. She's come back in. She was smoking.
That wasn't me.
Go over there and don't test.
I can go test. I can either pan out or do something to make that money up, but I can, yes, sir.
I'll grant the motion for. Thank you. Folks, my staff has reported that was you. And it appeared as though you were having sex on the screen.
No.
I believe she understands them and at this time has knowingly, voluntarily waived them and lay a factual basis to the added count.
May I have her sworn? Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
State your name, please.
Caitlin Quinn.
Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of use of methamphetamine.
You were right. I was wrong. Morning, Your Honor. For the record, Brian Stacy, P 33014.
1 year incarceration and $2,000 fine plus court costs. You understand that?
Yes, Your Honor.
All right. In understanding that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty, Your Honor.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct? Or had one signed on your behalf?
Yep. Yes, Your Honor. Yep.
All right. Any question regarding any of those rights?
No, Your Honor.
You understand you're giving up those rights on that form,
Yes, Your Honor.
particularly the rights contained in paragraph 5. If you look on the podium, you'll see a copy of the advice of rights. Understand you're giving up those rights as well as all the rights that are contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No.
All right. Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes.
And amphetamine in your possession?
Yes, I did, Your Honor.
Did you use it?
I did, Your Honor.
And did you know what you were using was methamphetamine?
Yes, I did, Your Honor.
All right. Ma'am, if I accept your plea, I have to advise you that if you commit misconduct as defined by the Michigan court rules, between the time of my acceptance of your plea and the time of sentencing, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. You understand that?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Defense is not aware of any, Judge.
All right. And have I complied with the court rule?
And defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed.
This plea was accepted only after Judge Simpson established 3 essential points. The defendant understood the rights she was surrendering, admitted the conduct supporting the charge, and confirmed that nobody threatened her or made undisclosed promises. Her admissions that she possessed, used, and knowingly identified the substance as methamphetamine provide the factual basis the court needs before entering a conviction. Notice how the judge also questioned defense counsel. That creates an additional record that the plea complied with court rules and reduces the possibility of a later claim that it was involuntary. The dismissal of count 1 is the negotiated benefit, but sentencing remains unresolved because the judge ordered a pre-sentence investigation. That report can examine her background, substance use, criminal history, and other circumstances relevant to punishment. The misconduct warning is equally important. If she violates the rules before sentencing, she may lose the benefit of any sentencing recommendation without automatically being allowed to withdraw her plea. Do you think her direct answers strengthened her credibility, or was the court simply creating a record strong enough to withstand a future challenge?
Pre-sentence investigation and report is ordered at 14A1. Probation sentencing will be set for February 11, 2026, 9 a.m. That's before me.
And that's here, Judge, correct?
That is correct.
And Your Honor, can I address bond?
Briefly.
Judge, briefly, my client has no prior offenses. The test did come back, the one that she appealed, and it showed the progress report. It said victims report negative for fentanyl. And I think that was one of the issues that the court kept her. And I think she would acknowledge that she did use cocaine after.
No, well, go ahead, counsel.
No, and I think she would acknowledge that she used cocaine after being placed on bond initially when you put her in jail since she's been in jail since January 8th. And she also, Judge, has been diagnosed. She was taken to the hospital while in custody for gallstones. Apparently she does not have any gallstones, but she has blood in her urine, and the doctors believe that she has kidney stones. So she does need medical attention.
Well, it was interesting. The reason I took a break was to go back and look at the video. And my staff reported it to me, and it did appear that that's what was occurring. So what I am going to do, not on the defendant's motion, I'm going to adjourn this out to next week, the 5th. You'll have to appear in person, ma'am.
Okay.
That way we can assure you're not smoking and not having sex while you're in court. Thank you. Bond will continue.
Understood, Your Honor. Thank you.
Wow.
Yeah. Wow. You should see the video. All right. Thank you. Mute her and get her out of my court.
This is more serious than an embarrassing virtual court interruption. Judge Simpson says his staff reported the conduct, then explains that he personally reviewed the video before taking action. That distinction matters because the court is not relying solely on rumor or an unexplored accusation. The defendant's immediate denial conflicts with both the staff report and the judge's own observation, creating a credibility problem before the underlying case is even resolved. Instead of granting an ordinary remote adjournment, the judge requires an in-person appearance so the court can directly supervise her behavior and verify that she is actually participating. He also continues the existing bond rather than immediately revoking it, showing that the response is corrective and controlled, not an instant punishment based only on the video incident. Defense counsel's medical argument may still matter later, but it does not answer the judge's concern about repeated courtroom misconduct. Did you notice how the judge's tone changed after reviewing the recording himself? Once a judge believes a defendant is being dishonest about something personally observable, how much harder does it become for that defendant to earn discretion on bond, scheduling, or sentencing?
Assistant Public Defender Don, if you leave on behalf of Mr. Shukai Capehart. Shukai Capehart, can you say your name, please?
Christian Shukai Capehart.
Andrew, I was not able to reach Mr. Shukai Capehart until today, so I would be requesting adjournment for that reason. I do have a green sheet, and I would like to address the bond violation.
Yeah, go ahead. Address his bond violation first.
Your Honor, so Mr. Shukai Capehart indicates to me, and this was verified when we talked about, we did not have a valid phone number for him that has now been updated, and we now also have a valid email for Mr. Shukai Capehart. So we're going to be in clear communication from here on out. Regarding the missing tests, he explains to me that he was overwhelmed with the arraignment and wasn't given paperwork, and he didn't realize he needed to contact community corrections. He does tell me that today.
He what?
He tells me he was feeling overwhelmed that his arraignment did not digest what he was being told he needed to do and wasn't given paperwork.
Well, then why didn't he answer his phone when the community corrections tried to call him?
They did not have a valid number, Your Honor, and that has now been corrected.
What do you mean they didn't have a valid number?
They had a number from a phone that he indicates to me was stolen. I would ask the court with letting Mr. Shukai Capehart test today. He does indicate to me that he would not be positive for anything except potentially marijuana metabolites from before he was placed on bond.
So he wasn't in contact with his attorneys, didn't go to community corrections, didn't do anything the court asked him to do.
Your Honor, I believe he wasn't attempting to make contact. He indicates to me.
Attempting to make contact with whom?
He indicates that he called our office and was not able to reach anyone. He also indicates he contacted this.
80 people work in that office.
My wife also.
And that his wife also attempted to call.
My wife was in contact. And had documentation of it and everything like that, but I had made it apparent to at my arraignment that I did not have an active 646 area code number. And I gave them 2 numbers that they could try to get a hold of, but I guess they only called the 646. And I had been in contact with people, well, my wife was, but I had no release paperwork or nothing. This is new to me. So
He's told it on the record that he needed to go to community corrections.
That is my understanding, Your Honor.
I didn't know that I was going to let.
I'll adjourn this out 1 week to the 5th. 2026, 9 a.m. You got to follow the court's orders, young man, or figure out how you're going to do that. But at this point, his bond's revoked, defendant's remanded.
The final ruling shows why communication problems rarely excuse complete non-compliance with bond conditions. The defense offered several explanations: an invalid telephone number, a stolen phone, no release paperwork, difficulty contacting counsel, and confusion after the arraignment. Any one of those details might justify limited consideration, but Judge Simpson focused on the larger pattern. The defendant did not report to community corrections, missed the required test, and apparently failed to establish reliable contact with either supervision staff or his attorneys. Most damaging was the judge's understanding that the reporting requirement had been stated on the record. That weakens the claim that missing paperwork made compliance impossible. Defense counsel strategically asked for testing that day and emphasized that any marijuana result could predate bond. But that proposal addressed possible drug use, not the separate failure to report as ordered. The judge therefore granted a short adjournment on the underlying matter while revoking bond and remanding the defendant. Legally and practically, bond depends on whether the court can trust someone to obey conditions and return when required. It is not simply a prediction about whether a drug test will be positive. Across these hearings, the same lesson keeps appearing. Credibility and compliance shape judicial discretion. Would you have allowed one final opportunity after the contact information was corrected, or did the number of missed obligations justify immediate remand? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.